It is August 5th, and welcome to Boca's Briefcase, where through the Boca Raton Tribune, we bring the community special speakers who can offer value and information on what's going on. I'm very excited. I just want to plug next week. We have, for those of you who are lucky enough to see Les Miserables when it came to town and when we were actually having shows in Broward, Josh Davis, Inspector Javert from Les Miserables. He will be here next week, and I definitely encourage you to, in the chat, ask him to sing some Les Miserables songs, and we'll see if he brings some other cast members as well. So that's next Wednesday at 2. This week, though, we're going to stick with the law as we usually do. I just came from speaking at the Rotary, which was great, about evictions, because my office at Zalman Law is constantly getting a question on evictions. Do I have to pay rent? Can I be evicted? Is there really a moratorium that's effective? Can I file lawsuits? I'm exhausted, but that's what I do every day. What I don't do every day is wills, trusts, and estate planning. And that's why we have Erik Eastham here today to help us answer questions about what's happening with estate planning during COVID and what are some tricks of the trade for all of us to have our documents in order. Erik Eastham is with Eastham Law Offices. I've heard him speak at endless conferences, networking events. He's very active in the community. I'm so impressed every time I hear him speak. He really believes in educating his clients, helping his clients. He works in asset protection, guardianship proceedings, will contests, business planning. He really covers the gamut. And again, we have him here because he loves participating in the community and offering value. So welcome, Erik, to the panel.
Thank you.
We're excited. So I want to just jump in and stick with the hot topic that we all don't love talking about, which is COVID. I heard you speak about a week ago at a networking event, and you were talking about some really important documents right off the bat that anyone can have right now to protect these circumstances. So can you tell us some advice on COVID documents?
Okay. So the big misconception that a lot of people have when they're thinking about an estate planning attorney is this guy's only going to be talking to me about what happens when I die. When in fact, that's a percentage of what we do, but a lot of what we do is create documents that help you while you're still alive. Right. And what we're talking about is healthcare documents. Some people will call them a power of attorney for healthcare. They're not to be confused with living wills, and living wills are not last will and testaments. But a healthcare document is, in the simplest form, a document that directs the doctor and lets the doctor know, or the hospital know, who may make medical decisions for you in the event that you are not able to make those decisions for yourself. And there's a lot of reasons why you may not be able to do that.
And I just interrupting for a second, because this is so important right now with the hospital situation. They're not letting in guests and even family members a lot of times. So having these documents executed in advance of possibly having a hospital stay is so imperative.
It's really important. We have been getting a call about once every 10 days or so. We're getting a phone call where someone says, I've had to put somebody in the hospital. I'm having trouble getting information. I need a healthcare surrogate. Before COVID had happened, our office would often have to do all types of documents being signed in a hospital. And we'd have to go there, and the people are okay. They have the mental capacity of doing it, but they can't get out of that hospital bed. Well, now the hospitals aren't letting us in. So I can't do it. And so the best that a client can hope for is having a willing hospital staff person witness their documents for them. And our experience is most hospital staff don't want to perform those services. They don't know what legal document you're asking them to witness and sign. They don't get it, and they don't want to be a part of it. And you can't make somebody witness a document.
So it's just like, God forbid, someone's in a car accident, this or that. You can't be, any emergency situation, like going to an ER, to a hospital, like what I was just saying, you don't want to be executing and signing things then. You want to have your affairs in order when you're calm in a nice, calm setting like Erik's office.
Correct. And if you don't have the mental ability to do it because you're unconscious, or sometimes you don't have mental ability to do it because the doctors have put so many drugs into you that you can't really stay awake or you can't think straight. If you don't have someone already appointed, you're not going to be able to sign that legal document. So you want to do it when you're cognizant.
Let's bring up a really hot topic right now is people, it's still summer because schools are starting later in some places. Sometimes people are sending kids to stay at aunts and uncles for the summer, possibly grandparents. And then when school does start, you're going to have children possibly staying at a family member's so that you can go to work. There's all different kinds of situations. Do you have recommendations if you're going to be apart from your children on documents that need to be executed, or is it the same thing?
So yes, what you can do is your child cannot sign a legal document themselves. They're not of legal age, so they can't perform legal acts. You as their parent can. And what parents should be doing, not just during COVID, but a lot of parents will send their children away to camp, or they'll send their children away to visit with their grandparents during the summer. And in those scenarios, they should be signing a power of attorney, allowing other authority figures to handle those medical decisions in the event that they're not going to be there. Now, if the grandparents are just up county, then that may be a little extreme. But I do have a lot of parents whose their parents, the grandparents, are living up in New York or Connecticut or something like that. And that's not always so easy for that parent to get to that hospital and talk to that doctor.
Right.
So in those scenarios, yes.
And by the way, to anyone viewing, I do talk a lot, so I welcome you to interrupt me. If you have questions for Erik, just type them here. Erik's friends or family are watching. Give him a thumbs up. Let him know you're watching. Send him a like. But yeah, you're welcome to ask questions, and it'll show up on the screen, and he'll address that. So sticking to children, I heard an interesting topic you once discussed. Older children, when you send them to college, what's your advice when you send kids away about how to sort of still, be a parent?
Even though a child reaches the age of 18, where our legal system says you are officially no longer a child, you are a full-fledged adult, many parents still parent those, what I'll call adult children over the age of 18. They don't have their own spouse. They don't have their own children. They're still learning a lot of life as they go. And I will get a call typically in the fall from a frantic mother who has said, my child is in the hospital. The doctor's not telling me what's going on. Well, I'm going to sue the doctor. I'm going to sue the school that they're going to because they're not giving me the information that I am the mother and I have the right to have. And the truth is, you don't have the right to that information anymore because your child is no longer a child. They're an adult, and we have HIPAA laws in place. And HIPAA laws, as many people do know, are the privacy protection laws in place in regards to your health. And that doctor doesn't want to get sued by your child when the doctor tells you, well, the reason why they're in the hospital is because they were drinking too much and they fell and they had an accident or whatever it may be. Officially, legally, that's none of your business. So what I tell my clients is you're paying the tuition, you're paying the housing, you're paying the food. Tell your kid you're signing a power of attorney before you go off to school, and you'll have that power of attorney when you need it. And not just for healthcare reasons, but a general durable power of attorney will also give you rights to access their grades and see what it is that they're actually doing in school.
Right. So thank you, Big Brother. but honestly, if you're a parent with a child in college, not such a bad idea. That's very good. So let's change the subject to a little bit and go back to COVID just for a second. Is there any other ways that you're practicing differently because of COVID, or are you maintaining the same, besides what we talked about with the healthcare directives, or what other advice could you give during this time?
The people that really need to think about this, which usually do not think about putting anything in place, are people who are single. If you are married, the hospital is going to talk to your spouse. The question is, what if your spouse isn't there? And I say single people because they just assume that the doctors are going to do what the doctors are going to do. But what if you are a single person, you have no guardian, you're an adult, you're elderly parents are not going to be able to just make decisions for you. Who do you have? Who do you have to make these decisions? Those are the people that really need to be putting these things in place in light of COVID. They should be doing them at all the time, but right now we're at a time where we have higher risk, a higher likelihood of having to have this virus and having to maybe go to the hospital. And we do hear cases about people who are unconscious and the doctors are doing everything they can. But guess what? People have different desires on what they want done. And some people want treatment and some people don't want treatment. And if you are silent on what you want because you haven't taken the steps to put it in writing, then the doctors are just going to do what they want to do because you're not there necessarily to tell them. Now, they're going to listen to you if you're awake and you're telling them what you want to do, but they've taken their oaths. They're going to do everything that they can possibly do, and that may not be in line with what you want.
So I'm understanding that if you want control of your own life, your own healthcare, there's documents that you can sign now to make sure those wishes are granted and how your healthcare is given. I received a text message. It didn't show up in this chat, but it's about trust. Actually, I have 2 questions on trust. So let's switch directions for a second. One was about leaving if a child is young, but is it I'm trying to summarize here, leaving funds for a child, where they get it like at 18, 19 versus waiting longer. What's your advice on leaving or creating a trust that involves children and receiving large lumps of sum when in essence they're still children?
So
that's a big subject, by the way.
It's a fantastic question. I'll answer it as concisely as I possibly can. I have 3 children myself. I'm one of 5, and they're all very young. So the general rule, number 1, you do not leave money to a minor child. Parents everywhere are doing this without even knowing it. And they do it because they go and buy a life insurance policy and they say, I've done the responsible thing. I bought a life insurance policy. So if something happens to me and my spouse, or if you're a single person, or if you're a single mother or father, I've taken care of business. There's a policy. It'll protect my child. Well, if you pass away, let's say your child's 10. The life insurance company is not cutting a check of your $500,000 policy or your $1 million policy to a 10-year-old. It doesn't work that way. Instead, what will happen is attorneys will be appointed by a court. Interested parties will get involved. Guardianships will be put in place. And by the time your child reaches 18, the court will simply then give them the money and say, best of luck.
Which is a windfall to have that kind of money at 18.
Most of us know or have an idea of what we would have done if we were 18 and received a lot of that money. I went to college and I liked being that guy who wanted to buy people drinks, but I couldn't do it. Guess what? If I had that money, I would have been buying so many drinks and probably more than that. Maybe taking buddies on trips and so on and so forth. I would not have made good decisions with a lot of money when I was 18. So the suggestion is first you look at yourself. When would that be? The second suggestion is that you do not have to give everything to your child at a certain time. And everybody's different and everybody knows their children. The most typical type of trust is a revocable trust, and that means you can change it. So if you're creating a plan for a child who's 5, it's very likely that you will want to change that because you will learn who that child will become as they get older in years. But we can plan for the worst case scenario, which is now. So what I do for a lot of children who are under the age of 10, we don't really know if they're going to be incredibly successful, if they're going to be more conservative with their money, if they're going to be more free with their money, what their intentions are going to be. So we say, let's spread it out at least over a period of 10 to 15 years. And we can put carrots in there, meaning you can get a little bit when you're 25, but if you get that college degree, which is important to some people, then you can get it a little bit early. Sometimes college isn't important to people. They just want them to have a trade skill or something of that nature. And we work with that too. And then a little bit more when you're 30, and then the rest when you're 35, or depending on how much insurance you have. I have a client who's got $3 million in insurance. Well, maybe spread that out to 40. And then I have other clients and they say, my kids not till they're 60. So it's different for everybody.
Step back for a second. When you're talking about this, are you talking about, is this in a will or is this in a trust? Because there's a lot of confusion, and we can get on this subject as well. Where are these directives being given? Because some people just get a will and they think that takes care of everything. It sounds like this might involve a trust too.
So it needs to be specifically written out what is going to happen. And you can write that out in a trust now, or you can put it in a will now to be done later. My experience is both are going to cost you about the same because it's advanced planning. You're going into very specific particulars.
Right.
You want to use a trust now rather than a will, because a will mandate a probate. And attorney's fees in Florida are dictated by the statute, and the statute says start at 3%. So if you just put it in a will, then before your children's trusts are going to be created, we're going to take 3% and give that to the lawyer. So instead, you're probably going to spend the same amount of money, just create the trust.
Well, can you go
very
back
complicated documents
to the very basics of law and tell the viewers what is the difference? I mean, this is the very basics of estate planning. What's the difference between a will and a trust?
A will only handles things, it only says to the court, when I die, this is who I would like to be in charge, and this is where I would like my things to go. It's a long process. It takes about 8 months to a year on average. And we do have to pay lawyers because the people are not representing themselves. If you say, my mom died, I'd like to go through this process, I'm just going to represent myself. You're not representing yourself. You're representing your mother. You're stepping in her shoes saying, she was the only one who could sign the deed to the house. I would like that authority. She was the only one who could sign on the bank accounts. I would like that authority. And the court's not just concerned with making sure that the beneficiaries get what they want. They're also making sure that the deceased person's debts are going to be paid. And everybody dies with a debt. Everybody owes Florida Power and Light for the month that they were. We have revolving debt that we just kind of pay off over the months. Whereas a trust is a way for you to avoid all those processes because you don't own it. The trust owns it. While you're alive, it's business as usual. You don't have different accountings. You don't have anything special to do. But when you pass away, it simply says, this is the next person in charge and this is what they're going to do. We don't need lawyers. We don't need courts. We don't need 8 to 12 months. And it's also an extra little bit of insurance in the event that something happens to you while you're alive and you can't take care of yourself anymore. We again won't need lawyers and courts and making sure who takes care of you. Your trust will say all of that for you.
And does the trust then continue on after your death?
Yes, at least for a short amount of time.
Okay.
The trust might say, when I pass away, give it all away. And if there's nothing else there, the trust is over. But the trust might say, continue to hold this for my child for X amount of time. And people have funny things. I don't like the spouse that my kid married. So hold it in trust unless they get a divorce, which isn't a good idea because you may be encouraging a divorce and you don't want to do that.
Right.
But people can say whatever they want to say. They can put in all the different things that they want to.
There's great stories. Like in New York, one of the richest widows who left all her money to her dog, right? Millions of dollars.
We do dog trusts.
Yeah,
we do dog trusts.
And by the way, to protect yourself here, this is not actual legal advice for you out there watching. You need to contact your attorney directly, whether it's Erik or your estate planning attorney, to apply this to your specific estate so that this is not misconstrued. But this is more of a discussion. Speaking of not really dog trust, but other things that you do, I want to make sure you get in there. Erik does so much for the community. And I know you offer discounts to different types of people, and you also have religious discounts. Can you discuss some of these things? I don't want to share
all the time, not just during COVID, but all the time. If you are a first responder, we'll put a 50% discount on your estate planning documents. Right now, I'm in the camp that I really do want my kids to go to school, and I understand I understand a lot of the teachers. I have my aunt is a teacher, my mother is a teacher, so I understand their plight as well. So during COVID, if you are a teacher or if you work for a school, not just the teachers, but if you work for a school, we'll give you a free health care surrogate. And then at any time, also this is all the time, not just during COVID, if people wish to tithe, we call it tithing on the way out. So what I'm saying is giving money to your religious organization. It can be whatever religious organization you want it to be. I will give you a 10% discount on yours because tithing is usually 10%. I'll give you a 10% discount on that. Or we'll do a free will. If all you want is a will, I'll do a free will for you. If you're going to tithe, if you want an entire estate plan, it'll be 10% off the estate plan.
Right.
It still kind of comes out to a free will.
And if people have meet with an estate attorney, or I can't speak for all of them, but for example, for you, every time they contact you for questions, are they being charged? How does that work? Because I could imagine there's a lot of questions, or are these kind of flat fee structures for people? Or at least
the way our office works, 99% of what we do is a flat fee. We always charge for a document being produced, and that's because sometimes it's typically someone who doesn't have children, but they have a lot of nephews and nieces. And I've had those people come in and they change their documents once every couple of weeks. They say they're in, they're out.
Oh my God.
I like the school they went to. I don't like that school that they went to. They're out. And so they can change it. So if I'm producing a document, but you'll always know the fee up front. But my clients do get to have free legal advice in regards to their estate. I can't comment on a lot of things. For example, I'm not going to talk to them about evictions and landlord-tenant law, because that's not what I practice. But in regard to what I practice, yes, they get to do that. And the reason why we structure ourselves that way is we're not a personal injury firm where we're going to get you a lot of money and maybe never see you again. We're talking about estate planning, and your lives will change, and you need to be able to pick up the phone and ask a question in regards to that change of life without worrying about getting a bill. I want my clients to be informed, and that could be marriage, death, births, all these different things happen in your lives.
Well, I think one of the most important things you touched on, and I want to make sure everyone understands this, is that if you don't have estate planning in order, then whoever is then going to be addressing your estate after you pass away might have to deal with something called probate. And if you don't have your documents or affairs in order. And Erik, how much would someone be paying in attorney's fees if they have to go through probate to handle their parents or whoever's estate they're handling? I mean, it's an exorbitant amount of money, right, that you'd have to pay.
It's a lot of money. So the statute says a minimum cost is going to be around $2,000. And that's when somebody comes and says, Mom only had a bank account with $10,000 in it. How do I get it? Well, you're going to have to now pay $2,000 just to go get the 10, which can be a lot of money. It's 20%.
And there's taxes too, right? And I don't mean to interrupt you. And taxes as well. There's a big.
There's no estate tax. Like, there is an estate tax.
Okay.
But almost nobody has to pay it. We like using the term the 1%. Right now, it's the 0.01% who are typically having to pay an estate tax. So it's not something we really have to discuss.
Got it.
If you're somebody who is worried about paying that, that means you have a lot of money, and there are ways to shelter from that tax. But for general purposes, the statute says the attorney should start the fee at 3%. And there's all these other things built into the statute that allow you to charge more. For South Floridians, the average home price is around $250,000. That's the average value of a home. So if you own a home, we're talking about nearly $9,000 almost just to transfer that home to somebody that you want. We don't want to do that. If you have a trust, we don't need to pay that fee.
Can you just imagine? I just want to pause there and make sure people understand. If you don't have your documents in order, if you pass away, for the example you just give, you're handing out $9,000 off the top just to transfer your home to someone you wanted intended to transfer the home to, but you didn't have your documents in order, like he's discussing. So you don't want to go into probate.
And it depends on your estate values. We've had those at $9,000. We've seen attorney fees go well over $100,000 just to transfer it.
So
I mean, we say just to transfer it. There's a lot more involved. That's the reason why probate takes 8 months to a year. But at the end of the day, that's a lot of money going to somebody that you didn't want it to go to. You want it to go to your heirs typically, or a charity, or wherever you want it to go. That's who should be benefiting from it.
Right. No, this is this is a very good discussion. I can't believe it's already 2:30. Generally at the close of discussion, I like the presenters to pull out whatever from your own briefcase, what you want viewers, colleagues, people to know right now. If you could give one piece of advice to people now, what do you want them to take away from this?
Procrastination is my best friend as far as my business is concerned, because procrastination results in probate, and I love doing probate. We make a lot of money doing it, sure. But it is not your best friend. And the two things that people should really understand is, one, this is not something that you just do on your own, because typically you can look at anyone else and you know that their situation is not the same as yours. So it needs to be properly planned for. And the other thing that we need to really understand is that this is something that we know can happen to us, even though we pretend it's not going to happen to us. And a person at age 25 years old has probably already personally known someone who has passed away at a very, very young age. And the older we get, by the time you're 35, you may have lost count of how many of those people. And guess what? They didn't think anything was going to happen to them either. And there's a lot of people, once they get, especially around age 40, they've heard those horror stories of how it happened. And yet they still will say, man, that's a horrible thing, but that won't happen to me. And it does. So I highly encourage you to at least take a little bit of effort, especially for people who have young children, people who have purchased a life insurance policy for this young child, but they don't actually have a plan for that policy. And saying that my brother, their uncle, will know what to do is not a plan. Even if you've told him what to do, he may not have the legal authority to do it.
These are very hard discussions. You're very good at these difficult discussions. Nobody wants to talk about this, but thank you for doing what you do. You're out there to protect people in our community. So again, Erik is here today to help provide that advice. If you are watching this after the live viewing, please feel free to reach out to his office. He welcomes calls. He welcomes questions. That's why he's here today. So thank you so much.
I will say that if anybody is listening and they say, I have a question, just call that phone number on the bottom of the screen and just reference this video, and I'll be happy to talk to you. You're not going to get a charge for it. If you've just got a question that you just want answered, please do so. Because I'm lucky enough to be one of those people who likes what he does. So I'm happy to talk about it.
Thanks. And he's not kidding. I've heard him for years. I don't even know how long, throughout our community in South Florida, speaking at events. I show up and there's Erik speaking. He's helped so many clients I know as well. So Erik, thank you so much for being here and for taking out your time. I know you've got the kids and work, so thank you. And everyone, please join us next week where we're just going to take a break from the law. And we have our special guest, Josh Davis from Les Miserables. Try to tell him to sing, so he will sing some Les Miserables for us right here. Thank you to the Boca Raton Tribune for always being here and giving us this platform. And I'll see you guys next Wednesday, 2 p.m. Bye, everybody.